Welcome back. The African Transformation Movement says it will oppose President Cyril Ramaphosa's legal review of Parliament's Phala report. Ramaphosa says there's urgency in determining the legality of the panel's report, its recommendations and findings. He filed an application in the Constitutional Court asking for direct access to those judges, saying his case should be heard there in the interests of justice and of the public. Earlier, the ANC said it had every right to use its parliamentary majority to stop the process. The party's NEC confirming yesterday it had told its MPs to vote against the impeachment process in Parliament. Then, last night, MPs agreeing to postpone a debate and a vote on the report to next Tuesday to allow MPs to be physically present for that meeting. Well, the President continuing to face criticism from some opposition parties. They claim he's created a parallel process by approaching the Constitutional Court. Well, let's speak to the constitutional law expert, Sfiso Nxumalo. He's live from the UK. He's a researcher at Oxford University. Sfiso, good evening to you, and thank you very much indeed for your time. This application seeks to overturn a report that was instituted by Parliament. Parliament is really supposed to decide if the President should be impeached. He obviously has a right to go to the Constitutional Court, but is he undermining Parliament in some way by doing this?
Firstly, hi Stephen, and thank you for having me. It's a great privilege to be speaking to you about this important matter. To start off with, I think one, I should admit that I was not surprised that the President decided to take this review to take this report on review. It is a terribly flawed review, in my view, report, and that's, I think it was begging to be reviewed. And as whether or not he's undermining the parliamentary process, I think the answer to that is no. I think there are two distinct inquiries that are going to take place. The first one is whether or not the report is within the bounds of the mandate, whether or not it was done lawfully, and whether or not it is irrational. And that is the question that the Constitutional Court has to answer. That is completely different as to whether or not the President has violated the Constitution in a manner that is serious and deliberate and in bad faith. That is a decision and a question for Parliament to answer. But it's actually very important, and I would say crucial, that we know whether or not this report is flawed. And if it is flawed, then surely Parliament cannot rely on a flawed report. That would taint every other process and every other step that it takes going forward. So I think this is a necessary review application. I suppose the only concern is whether or not it is premature, as Parliament has not decided whether or not to impeach. So that is a separate question, but I don't think that it is undermining the work of Parliament. I think it actually might enhance it, because it might ensure that it is relying on a document that is not flawed and is legally sound.
His application, as I understand it, I haven't read the whole thing, is quite critical of the report. It attacks the way the panel approached the evidence. It says that some of the evidence can't be verified, which to me was always going to be an issue with some of the information Arthur Fraser had made public. It claims the findings cannot be justified under the terms of reference. So from what you're saying, do you believe the President has a strong case?
Firstly, I think the President's papers, I think it's about 56, 57 pages. It's a comprehensive affidavit, and it touches on what I would say are very important points. And I think these are points that a lot of legal commentators have picked up on. So, I do think that he has an exceptionally strong case, barring, of course, a few issues which I think, depending on what the ATM argues, some of them would be that, this is a preliminary non-binding report, and therefore the President cannot review it, and there's case law to that extent. However, on just looking at it substantively, I think it is spot on. The panel seems to have made a very odd choice between saying, well, it's going to give us prima facie evidence, or that there is a case to answer, even though the terms of reference speak about sufficient evidence. And I think to many of us, the knee-jerk reaction is that sufficient evidence is a much more higher threshold than prima facie evidence. It relies largely on hearsay, which is unsubstantiated. And as you rightfully pointed out, the perhaps this should have been seen from the beginning. And this raises another question that, was this panel really dealing with a insurmountable task? So effectively, the evidence that it had could not be verified, and it doesn't have the tools to verify it. So maybe it was actually, it was meant to it wasn't going to achieve much from its inception, and perhaps we should give it some respect due to that. But it did do a terrible job. And I think one has to look at this in the backdrop of impeaching a president, a democratically appointed president, or democratically elected president, pardon me. So therefore, we would want a report that is excellent, well-reasoned, and has no gaps and has no flaws. And unfortunately, this gives us the complete opposite. It is ripe with complete flaws, which I think are absolutely ripe for overturning.
Sfiso, I know you spent your own time at Constitution Hill, so I hope I don't put you in a difficult position when I ask you this question. But it is astonishing that a report written by a panel chaired by a former Chief Justice, Sandile Ngcobo, can face the kind of criticism that you've given. And if I may just say, you're not the only one. I've heard plenty of criticism from various people. Look, there's some people who back the report, but I've heard plenty of legal criticism of the report, some of it along the same basis that you've given. You make the point, surely correctly, that you need the best kind of report, an excellent report. You'd give it to a former Chief Justice. And yet that's not the report that we got on your version.
Yeah, unfortunately, it woefully fell below the required standard in my opinion. And of course, this is the first time that such a panel has been instituted, and therefore there will always be some difficulties and some growing pains. But I think on the merits, it just was a very shoddy report, and I wish, it was a little bit stronger, because I think that the charges that the president is faced with are quite damning, and they are quite important. So therefore, we would want the rigor that we can't question, we can't interrogate, and we would simply say, well, this is profoundly strong. And unfortunately, the panel did a great job, and they did it within a very great job in the sense that they had a lot of evidence to go through, and they had a very short period of time to do it in. And I think they delivered. However, whether or not we are happy with the services they've delivered, that's a completely different question. And unfortunately, as we've seen before, the mere fact that you are a Constitutional Court justice, or the Chief Justice for that matter, doesn't make you immune from being wrong. In fact, I think every other Chief Justice in this country and any other country has been wrong in many instances. And I'm not saying that the panel in this instance was wrong on finding whether or not the president has a case to answer, but I'm just simply saying that the reasoning and the procedure that they have followed is wanting, and it is lacking in rigor.
Before this started, the organization Judges Matter made the point that this was going to be judges getting involved in a very intensely political arena, and so it's proven, so it's been. Do you worry that no matter what happens now, the judiciary are going to be dragged into politics? I mean, this is the most political situation one can imagine, and judges in the panel, judges in the Constitutional Court, right in the middle of it.
Yeah, so, unfortunately, I think our constitutional design makes it quite difficult for us to delineate quite clearly what are constitutional matters and what are, political issues that only political arms of government should answer. I think our constitutional design, as we know, Section 2 of the Constitution says that, our Constitution is supreme, and any law or conduct will be tested against it. And then we also know that in terms of Chapter 6, that the judiciary, and especially the Constitutional Court, is really the final arbiter or the final interpreter of the Constitution. So therefore, they will always find themselves in a terrain where they will have to question what we would call political questions. But also, we should never be naive, when it comes to these questions. We should always accept that if there is going to be a constitutional debate, a constitutional issue, that there will be issues of law, and therefore the Constitutional Court will be brought in. And just to cite a previous decision by the Constitutional Court, Mwelase, I think it was decided 2019 or 2020, written by the retired Justice Cameron. He says that, we shouldn't use the separation of powers as a boogeyman to not interrogate certain legally flawed processes by the state. In that particular instance, it was about the land court and the appointment of a special master. So the answer to this is that yes, it was inevitable that it was going to involve judges, and we should praise it, we should welcome it. The only thing that I think we should not confuse the court dealing with these legal issues as the court making the decision for Parliament. Parliament still has to actually decide whether or not the president is in fact guilty of some of these crimes and some of these violations, and then decide whether or not they want to impeach him. The Constitutional Court could never do that. It is constitutionally constrained from doing that, but it is constitutionally empowered to interrogate the legality of some of the decisions taken and some of the methods employed.
Sfiso Nxumalo, thank you very much indeed. Constitutional law expert and researcher at Oxford University.